programs in Columbia County. An evening of Italian New York Vespers to be given at the Middle School Auditorium in Hudson, New York. Vocal soloists, the Hudson Valley Choral Society, and the Clarion Concerts Orchestra will be under the direction of Newell Jenkins. 8 o'clock is the time. Also on Saturday, and also at 8 o'clock, Kazuko Hayami plays a piano recital at the Church of the Messiah in Rhinebeck, New York, part of the season of the Rhinebeck Chamber Music Society. Here in Albany, again, Saturday at 8, soprano Caroline Utes can be heard in a faculty showcase concert at the SUNY Albany Recital Hall, with Joanne Rautenberg as accompanist. If you'd like to play music instead of just listening to it, there are openings available in all sections of the University at Albany Community Orchestra. Rehearsals are Tuesday and Thursday evenings, and university credit is given for those registered at SUNY. Several public concerts occur throughout the year, often featuring soloists and a repertoire of traditional and less well-known music. Anyone interested can call the University Music Department during the day and ask for anything else. Right now, it's time for Dateline. Later at 8:30, we'll bring you our regular Tuesday evening broadcast by the Chicago Symphony. Music director Sir George Schulte conducting, and with Dame Janet Baker as vocal soloist this week. The following program is made possible in part by grants from Schneller's Meats and Restaurant in Kingston, New York, purveyors of imported cheese and prime and home-smoked meats, and Mohonk Mountain House, New Paltz, New York, a National Historic Landmark and all-season family resort.
Good afternoon and welcome to Dateline from WAMC News. I'm Maury Small. In the next half hour, we'll have news from around our region. Then at 4:30, Monitor Radio, the radio news program of the Christian Science Monitor. And stay tuned at 5 o'clock for All Things Considered from NPR. New York's highest court heard arguments today on the regulations to restrict smoking in public. Two lower courts have rejected them. New York farmers protest an appearance by the federal agriculture secretary. One farmer in our region reports his apple harvest will be the worst ever, thanks in large part to the freak snowstorm 10 days ago. A Massachusetts law is proposed that would ban toy guns that look like the real thing. Democratic presidential candidate Jesse Jackson has made some disparaging comments about New York. We'll have commentary today from WAMC's political analyst, Dr. Alan Shartok. All this right after the top headlines from the Associated Press on Public Radio, WAMC in Albany.
The judges of the court. Hear ye, hear ye, hear ye. All persons having any business before this Court of Appeals, held in and for the state of New York, may now draw near, give their attendance, and they will be heard.
Boreali versus Axelrod.
Ready for court.
Mr. Schiff.
Chief Judge Walker, may it please the court. First, I'd like to reserve 3 minutes for rebuttal, if I may.
If you find it necessary.
This case involves a challenge to the regulations of the Public Health Council, which were adopted in February 1987, restricting smoking in public places and places of employment. Those regulations are based on the Council's finding that environmental tobacco smoke or secondhand smoke constitutes a serious health hazard to non-smokers.
I imagine we're concerned with whether the Public Health Council has the power to do such a thing.
Well, we think that the court below is simply wrong in finding that even though they found that there was a proper delegation, or that it was within the delegated authority, and even though there was a serious health hazard, that it couldn't have been delegated the way it was because the regulations have severe economic and social restrictions according to the court.
Well, does that delegation, how broad is it? Can they regulate everything that has to do with health in the state of New York?
Within limits, we believe that the delegation is broad enough to delegate all matters of public health within the state of New York. And I'm emphasizing public health
So if they find that, for example, cholesterol is dangerous to one's health,
Well,
they could regulate the amount of fat content in meat sold?
I think most of the examples that were given in our opponent's brief, which is cholesterol, I think is one of them. The protection against cholesterol in that context would be basically protecting people from themselves. And we think that that may not be within the scope of the Health Council's jurisdiction. As we have pointed out in our brief, classically, public health is when something is injected into the environment, whether it be a virus, a bacteria, or a substance like environmental tobacco smoke or radon, which will affect third persons. One person puts it in, but affects adversely a third person. That's basically essentially the concept of public health. Now, we're not trying, I don't think this court has to define the ultimate limits of what the Public Health Council can and cannot do.
What other checks and balances would there be then, since
Well,
at least with the legislature there would be the check and balance of the executive support or veto of a particular piece of legislation?
As I think it's basically as this court defined in the Hillebo case, Judge Bellicosa. And that is why we think the court below is quite wrong. Both courts below were quite wrong in saying that the issue of health is not here. That one of the limits is that there is a need to make a showing, a finding, that you are dealing with a real health hazard. And most assuredly, there is ample basis for that conclusion here, which was not challenged.
Mr. Schiff, let me put a proposition to you. We all know that auto emissions and factory emissions are dangerous and could conform with your other definition with respect to dangerous to other people. I would imagine we would be somewhat reluctant to say, or maybe you wouldn't be, that the Public Health Council could regulate auto emissions or could talk in terms of the output of factories as far as pollution is concerned.
Well,
any
Your
problem
Honor,
with that?
originally, let me say, one thing I didn't add before in answer to your first question is that the Public Health Council cannot act where the authority has been vested in another agency. I think the area of auto emissions probably has been preempted to, in this case, environmental conservation
fair
and
enough.
motor vehicles. But originally, as Judge Levine in his dissent pointed out, the Public Health Council did deal with emissions from power plants, air pollution. There are a lot of things that they dealt with originally that now have gone to some other agencies. They dealt with milk, which was later transferred to the Department of Ag and Markets, and some of the aspects of, they still deal with water to some extent.
So in other words, you say that although this could have been termed as a delegation, as soon as the legislature acts in the area, it takes it away from the delegated authority?
Oh, of course. The legislature can always override what the Public Health Council does. And as a matter of fact, this delegation...
And not by specifically pulling it away, but by acting in the area.
No, not by just acting in the area. I think by actually giving it to another agency. I mean, there are subjects in the public health area, such as the air pollution, outside air pollution, and various aspects of water pollution, which have been given on a very comprehensive basis to the Department of Environmental Conservation.
But anything that's not so given, that relates to other people's health, this is not a trick question.
No. We've been through all of these before.
Yes.
Anything else, I think, probably comes within the confines. Then there has to be a rational basis for it. And it has to be, as it was said in Hillebo, that you, in fact, have to be dealing with a health issue and that you're not using this as a ruse to do something else. And we think these regulations, by all standards, comply with those strictures.
Are those then, Mr. Schiff, all of the limits? Have you now stated all of the limits?
I think so. I mean, those are the limits as we see them. And in some cases, there may be difficulties in determining how they apply. In this case, we think that there is no problem whatsoever. And I'd like to emphasize...
May I ask a question? Assuming that there's no preemption, as I read the third department decision, it does not say that this does not affect public health. It says such dramatic changes in public policy, however meritorious in terms of public health, are the function of the legislature, not an administrative agency. And in our view, the PHC has not really implemented the legislative direction, but has effectively usurped the prerogative of the legislature. Now, assuming a situation which is not like air pollution or the water pollution which you've alluded to, where there might be preemption of the field, but one where there isn't, can you give me an example of any situation dealing with a subject matter within the health field which would not be a proper subject of regulation?
Well,
Is there anything that...
Well, as I say...
Is there anything
basically
within the field that the commissioner couldn't regulate by rule that isn't preempted?
My basic answer is that I don't think that I can't tell you a limitation where it is a matter of public health. The commissioner does not claim that his function is to protect people from themselves. We think that's a matter of private health, and I guess Judge Hancock, as I told the Chief Judge, I'm not sure where one draws the line, but we think it's clear that the line is not overstepped here. We don't think that the question of a delegation is judged on an overbreadth doctrine, that because maybe something might be bad some other time, that therefore this regulation does not come within the very specific delegation that has been given to the
Schiff,
council.
what if I were to suggest this as a place to draw the line? And what if I said that in those areas where we're dealing with the esoteric as far as healthcare is concerned, the use of and strength of X-ray machines, some areas which wouldn't necessarily fall within the immediate ambit of policy-making, legislative concern and direction, that's what the Health Council was supposed to be directing its attention to, as opposed to things which are of such general public policy considerations, such as smoking in public.
Well, I don't think smoking is any different from other health problems, at least in terms of secondary or environmental tobacco smoke. This is an emergent problem which was not accepted by the public health authorities until 1986, essentially. Now the information, the epidemiological studies seem to have come together, and our Public Health Council reached the conclusion, the Surgeon General has reached the conclusion, the National Academy of Sciences have all reached the conclusion that there are serious problems to third persons, including the risk of cancer from environmental tobacco smoke. Now, this isn't a general policy decision, and this is why the court below is all wrong. This is a basic health problem, and it's one that's exactly what the Health Council was designed to cope with in 1913. This problem is no different from any other problem. Sure, if the legislature decides that it doesn't want to take the precautionary steps that the Public Health Council has now found necessary, it can, through affirmative action, withdraw some of that delegation that it has given under 225(5)(a). But it hasn't done so, and it would be a terrible tragedy for this court to eviscerate the scope of 225(a) on some conjectural theory that this affects social and economic policies. There are all sorts of delegations which probably have a much greater economic effect, at least, than this. There is nothing in this record to show any really serious economic consequences from the restrictions on smoking. has no need to do any construction.
Just talking generally about the very difficult line that has to be drawn between what is the proper legislative prerogative and what is proper for the executive exercising rulemaking power. Do you consider that whether or not the subject matter has broad public policy implications is a factor in drawing that line?
I don't really think it does. I think the question is whether it comes within the delegation. Now, in the Levine against Whalen case, much the same argument was presented. The Third Circuit, throughout the regulations there, this court sustained the regulation. In the Hillebo case, you can say it's a narrow question of ionizing radiation and chiropractors, but chiropractors have been sort of, at least in those days, were certainly viewed as anathema by doctors, and I think that's why in the Hillebo case, the court said that the regulation has to be one in fact as well as in name, and they were very concerned with showing that there were real health concerns, and I think that is what the court, in construing this delegation to the Public Health Council as to what it can do in the sanitary code, it has to keep its eye on the ball. Is it a serious health problem?
What about conventions?
It is a serious health problem, but it is not one that will jeopridize people from some limited contact. The Public Health Council...
It's all right, it's not unhealthy to smoke at conventions, but otherwise...
Judge Wachtler, it's unhealthy, I assume, to smoke or to inhale smoke.
So why do you exempt conventions?
Because the Public Health Council, like any other agency, also has the obligation to balance, under the Administrative Procedure Act, to balance the economic and effect on other people.
So that in addition to health considerations, you're now starting to weigh some kind of policy economic considerations.
That's been true in all environmental regulation. There's a certain amount of balancing, and I think the Health Council was constrained to make that kind of balancing in view of the SAPA, and as long as it did not believe that this would in itself cause a serious health problem. Now, these regulations are sort of a place...
Unless you happen to go to a lot of conventions.
Is the Public Health Council above the legislature?
Of course not.
Well,
it's acting...
Hasn't the legislature taken this under consideration many times? And haven't they passed legislation with regard to not smoking in certain places? And I'll agree with you, smoking's bad for your health.
In 1975, Judge Titone, the legislature enacted the 13E, and it did not consider this. At that point, there were no findings that...
It didn't consider that. I know you have your red light, so let me just cheat a little bit for you. They didn't consider it, but hasn't it been brought up, and haven't they refused to act on it?
I think your cases show that a mere refusal to act where there isn't a policy, the positive policy does not provide a basis for divining some new legislative policy. We suggest that the legislative policy that controls here is a delegation under Section 225A.
I'd just like to ask, if I could, one question on that. Is the fact that they chose to legislate in that area a recognition by the legislature that smoking in public places is something that they consider proper for them to speak on?
Well, they recognized that it was proper to speak on, but they didn't say it was exclusive. Indeed, before this one, the Public Health Council adopted regulations as with respect to, I think, in restaurants, and the Health Department adopted with respect to hospitals, and there's been no suggestion that the single legislation dealing with smoking as a nuisance was preempted. There is a parallel area of legislation by the legislature and interstitial legislation. We suggest the case is not materially different from, I think, the Grossman against Baumgarten case, which we discuss in our brief, I would like to reserve the rest
Yes, you
of the
do
time.
have reserved time for rebuttal. Thank you, Mr. Schiff. Mr. Costello?
Thank you very much, Chief Judge Walkler. Chief Judge Walkler, citizen members of the court, we are fortunate to live in this country where the Federalists recognized very early on, Alexander Hamilton, a New Yorker, recognized that we have to protect ourselves against ourselves by installing a system of checks and balances. And I think what Mr. Schiff is trying to urge this court.
Alexander Hamilton didn't even want a Bill of Rights, though.
That's correct, he didn't.
Don't we have some kind of right?
We were fortunate enough to, not to, well, go ahead.
No. Thank you.
Yeah,
Don't we have a right to have a healthy environment? And if there are those who are inconsiderate enough to smoke in public places, what better agency than the Public Health Council to say no?
Well, Your Honor, to read this particular statute, 225-5A of the Public Health Law, as Mr. Schiff would urge you to read it, that is without any limits, would permit David Axelrod, the Commissioner of Health, who, interestingly enough, fashioned his own definition, it's his footnote 6 in the brief, of what public health is, which was an 1850 Massachusetts definition of man in his perfect state.
Well, they've defined some limits here. Now, they've said that one of the purposes is to protect people from others where they can't otherwise protect them. They're trying. I have no way of stopping people from smoking in a restaurant when I go in there. If I want to eat out in a restaurant, I'm subject to the abuse that they're going to render to me. Why isn't that an appropriate subject for the Health Council?
Well, because to read it the way it's being suggested here, which is basically concurrent authority with the legislature, Your Honor, would be to permit the Public Health Council to act in any circumstance affecting not only public health, but health and the security of life. The studies that Mr. Schiff spoke of show that there's a great hazard of...
Where we can protect ourselves by personal choice, they have no jurisdiction. Where we can't protect ourselves from the conduct of others, they have a right to step in and see if they can advance the public health. What's wrong with that?
Well, Your Honor, I'll give you two examples of why that's wrong. First one is that some of the major studies in the early 80s on this particular subject dealt with spouses and smoking in the home.
Well, they haven't tried to take care of that.
They haven't tried to take care of that yet, Your Honor, but if they can deal with any matter affecting the health or public health or the security of life...
But the home isn't generally considered a public place, is it?
No, Your Honor, but they're not restricted to a public place. There's nothing in the statute that would restrict them to a public place. They can deal with any matter affecting health.
Between spouses is not generally considered a public health problem.
No, Your Honor, but the statute permits them to deal with any matter affecting not only public health, but health and the security of life. I would also suggest that a woman in her third trimester, under this definition and under the theory advanced by Mr. Schiff, could be, I suppose, under Dr. Axelrod's aegis, be forbidden from smoking or using alcohol. And I suppose, Your Honor, that they could prohibit the sale of those products or any other product.
We're trying to test Dr. Axelrod's definition. We're trying to test the exercise of jurisdiction in this limited circumstance here. Now, he's defined certain limits to how far that power goes. And what's wrong with those limits?
I don't believe he's defined a limit, Your Honor. I believe he's asked by the Chief Judge whether or not when you draw the line here...
Well, what do you think of a limit that he stated where the Public Health Council's power goes to protect people from the actions of others where they have no other way of protecting themselves? What do you think of that theorem?
Well, Your Honor, I think that basically is a legislative responsibility. Your Honor, the hard choices, in a case you decided in June, I believe, called Monarch Electric, you pointed out that hard choices have to be made by the legislature.
Well,
I believe this is that type...
Exactly with the statute there.
Pardon me, Your Honor?
We were confronted exactly with the statute there.
Well, here...
Legislative expression there.
Here, Your Honor...
Here we're trying to determine the extent of the delegation of power.
That's correct, Your Honor. And here, in order to make that determination, we have to make a realistic appraisal of all the various factors, including the thing to be regulated. Here, public smoking. And here, the question was asked by Judge Titone, what about other legislative action? In 1975, this legislature selected, among many options, a particular bill which Senator Dunn, Deputy Majority Leader today, sponsored. And that bill prohibited smoking in certain public places. There were many other bills at that time involving many other public places, or places where the public can go, that were rejected. Subsequent to that legislative selection, there have been 40 other attempts to expand that. The legislature has said no, and twice when the governor introduced bills, that is in 19 through sponsors, in 1983 and 84, that first year there were 66 affirmative votes, and the second year there were only 62 in the Assembly, obviating any need for Senate action.
But Mr. Costello, on the distribution of powers, isn't there still potentially a checks and balances effect in that this can be viewed as executive branch action subject to modification or nullification by the legislature?
Well, Your Honor, that would be basically, I think, put us in a position of the legislature constantly trying to recapture power. That would read the statute 225, which used to be 2A in 1913, as a statute which essentially gave all the control over the public health or health matters to an unelected body appointed by the governor. And the legislature, if they didn't like any particular thing that that body did, would then have to recapture that power back.
Well, there'd be another check and balance in the Hillebo case and in this case. Also, the third branch, the judicial branch, could be involved. Isn't that a nice even distribution under a checks and balances theory?
Well, that's why we're here today, Your Honor, yes. But I believe on the theory that...
Yes, that's a good checks and balances, or...
Well, Your Honor, under this theory, and as it's espoused, and to permit that concurrent jurisdiction, which I believe that we're talking about, would, to use a word you used not too long ago, transmogrify the Public Health Council.
That was in a dissenting opinion.
I noticed that, Your Honor. Into a super legislature. They would, in fact, be creating the policy in this state. That, Your Honor, is not what our Constitution's about, and the legislature should not be forced into a position where they have to recapture power constantly, particularly if there's a veto involved, or a threat of a veto, as there was in this case earlier, where they would require basically a two-thirds vote in order to set state policy in this area.
If I understand your argument correctly, it's really twofold. First, you say there is no such delegation under the Public Health Law 225, and as I read 5A, that's very broadly worded.
It is, Your Honor.
But you say some subsequent legislative action indicates that this sort of thing would not be within that delegation. And second, you say, as I understand it, even if it might be considered to be within that delegation, it violates the Constitution, it violates the checks and balances, legislative versus executive branch. Now, if you were going to go on the second proposition and draw a line, what would there be about this enactment, this rule that has been made, which casts it into the legislative rather than the executive realm? What is there about it?
Well, in this particular, there's been a number of cases, Your Honor, and the chiropractic case, which was decided by this court in 1962, dealt with, I believe the chief judge used the term an esoteric, but it's a technical area. It was not practicable in that case, it was determined by Judge Van Voorhees, to go any further in terms of the legislature setting forth any further guideposts. Very interesting. I believe that case stands for the proposition that for purposes of ionizing radiation, the standard is sufficient as it's set forth in the statute. For other purposes, where it is practicable for the legislature to go further and set further standards and guideposts to guide the administrative agency, then, as in the case of public smoking, where it's clearly been practicable, they've done it in 13E, then the administrative agency is without power to step in and effect legislate. Now, chiropractic was grounded on a case called City of Utica. And in City of Utica, when read, and I think that's a very important case in understanding chiropractic, there was a broad grant of power. However, after the broad grant of power to deal with water pollution, there were 4 or 5 detailed standards involving what formulas should be used to test the quality of the water, who should do the testing, and a number of other standards set forth, which in effect gave guidance to the administrative body to go forward and complete their duties. Also, in the matter of Levine against Whalen, which is also a basis for chiropractic, while there was a broad delegation of public interest, Section 2800 of the Public Health Law is a section of law that, when read, very clearly points out that the legislature, in the narrow area of hospital regulation, gave to the Department of Health the power. In fact, what it says is it permits them to establish state's policy with respect to hospitals and related services. So in those areas that are inherently self-limiting, such as ionizing radiation, a subject that's inherently self-limiting, or in areas that are inherently self-limiting, such as the racing cases, the utility cases, the cable TV cases, in those kinds of areas, then there does not have to be as much detail in terms of what the statute would provide. And I would suggest that that line is drawn precisely where the Chief Judge suggested.
Well, that wasn't a suggestion.
Could be drawn.
All right. Let me ask you a question, Ms. Costello, going back to something you said a moment ago with respect to preemption. The fact that the legislature proposes certain legislation in an area which doesn't pass, does that mean that that is to be taken as the legislative statement to the effect that it has retained jurisdiction over that particular area? Because I would assume that if we look back at all of the bills proposed in the state legislature which did not pass,
yes,
that we would find that there's very little else for anyone to do anywhere.
Well, Your Honor, in any legislative session, a 2-year period is about 12,000 bills, and maybe
precisely
200 of them become
law.
So
when you cite those particular bills which did not pass, they really don't stand for anything, do they?
Well, Your Honor, you rendered a decision, I believe, today, which does refer to that. Judge Belcosta wrote that determination. This is different because what happened in this particular instance is a legislative selection was made in 1975. A determination was made at that time. There has been urgings made by the governor, by the Commissioner of Health, by many interest groups to change that legislation. The legislature, in the course of consistently 40 times, and a number of them being voted on, has refused to change their original decision, which is that public smoking should be banned in certain areas, public areas in the state of New York. They refused to change their mind about that. They came to it selectively, rejecting other alternatives.
What if the legislature passed a bill tomorrow which said that the area or the concern of smoking in public places is one which will be reserved to the legislature? In other words, they didn't say whether you could or you couldn't. They simply said it would be reserved to the legislature.
Yes, Your Honor.
How would that strike you?
How would that strike me in view of this particular Part 25 being in place, Your Honor? Well, I guess the first question should be, I would think that they wouldn't have to do it, Your Honor. They've already reserved it. I don't think it's necessary for them to have done it.
If they did do it, you'd feel much more secure, though, wouldn't you?
I don't think I would. Well, I suppose I would, Your Honor, but I don't believe...
They could do that very easily without even saying yea or nay.
I don't believe it's either necessary, Your Honor, or do I believe if they pass something like that, it necessarily... They have the power to create a bill. They don't have a power to make a law without concurrence by the executive. So if you would suggest in your hypothetical that the governor would also agree with that...
You're not subscribing then to the concept that having made this broad grant of power previously, that by selecting areas in which they are active, the legislature has merely said, pardon me, not that we are preempting the field, but rather that we will deal only in this particular area, and the agency can continue to deal in those areas where we have not spoken.
I don't believe that that's what's occurred here, Your Honor. To read it that way, I think would say that if they had gone to a certain point and stopped, then there would be power in the Public Health Council, for example, to amend, I suppose under this theory, amend practically any statute in the public health law. Many times in under 21, in a number of other cases, Rapp against Carey, this court has taken a position that you can't expand a statute, no matter how desirable the idea may be. The subcontractor's case, all those cases basically pointed out, as did this Monarch Electric case recently.
This statute is a fairly broad delegation, is it not?
Your Honor, it's broad delegation, but in order to save its constitutionality, it is necessary to imply some limits. And those limits, if they're going to be implied, and they were implied by this court in the Hillebo case, have to be either to a subject where it is not practicable to go any further, such as ionizing radiation, where there's a technical body to deal with a technical subject, and as Judge Van Voorhis pointed out in that case, we have an area that's much better left to a technical board than to lawyers and legislators. Then in that case, it's perfectly all right. Constitutionality is saved. But when you go beyond that into an area that affects everybody in New York State, and it's a situation where hard choices have to be made because it does affect people in their social and their economic and their business, it affects labor unions, it affects everyone.
Mr. Costello,
In that situation, you have to imply some limits.
Part 5 of the same body of the NYCRR governs and regulates with respect to drinking water, does it not, in terms of organic and inorganic contaminants
Yes,
with respect to cancer? That pretty much affects everybody in our society as well, does it not?
It does, Your Honor, but there is a specific part of 225(5)(a) that permits them jurisdiction over that particular area. And, Your Honor, that's true about, there's many sections of the Public Health Law 225 which has specific grants of authority to deal with specific subjects. There's also a section 225(5)(a), it's subdivision, a subdivision of that, which would require the Public Health Council, if they determine a problem which is under discussion, has health impact, their function is to refer that, and to refer that information, and to urge the legislature to make a particular determination with respect to this, to conduct those studies, and to make a determination and make a recommendation to the legislature. This they have failed to do, Your Honor, in this particular case. They did it in earlier years because these studies, it's not new evidence the Surgeon General found. These studies were all available in the early 80s, and they continue to come available now. Some suggesting dangers, some not. It was for that reason there was a stipulation in this case, Your Honor, to just deal with this question of authority as opposed to any factual independence. Thank you, Your Honor.
Thank you very much, Mr. Costello. Mr. Schiff?
I think the last comment was a suggestion that the stipulation somehow said we don't concede that there's a health problem. The fact of the matter is that the complaint in this case didn't challenge the health effects or the hazards. Stipulation simply said there's no issue of fact in that context, and that context is that the health problems from environmental tobacco smoke were conceded, and they're very real problems. There's no difference here than from other diseases that the Public Health Council has dealt with. I think that all we're asking this court to do is to reaffirm its view of delegation under Utica, under Hillebo, under Levine against Whalen, and under the many other cases that have followed. There are many regulations of administrative agencies that have far-reaching impact. The drinking water one, and we don't think that there is a specific provision in 225A relating to drinking water. But over the years, the Council has generally acted on broad subject matters without there being any specific language in 225A. Most of those provisions that are now in came later. The last provision, which was referred to in our opponent's brief, relating to bottled water, is a case where the legislature chose to have things more restrictive than the previously extensive regulation, not predicated on any particular provision, but on 225(5)(a), wasn't as restrictive as the legislature thought it should be. We think that the legislature adopted the sanitary code provisions in 1913 to give the Public Health Council the ability to deal with new and emerging health problems. That authority should be reiterated here. The factual predicate that was also present in the Hillebo case is present here. And incidentally, the legislature chose to modify the restrictions on what kind of x-rays could be taken when they decided to license chiropractors a few years after the Hillebo case. It wasn't as if the legislature couldn't act. That's true in many cases. but the legislature has left the council free to deal with these problems. It's important to protect the public health of the people of the state of New York, that this authority not be diminished. Thank you very much.
Thank you, Mr. Schiff. People ex rel Brown versus New York State Division of Parole.
Can't see the courtroom at the end of an argument.
Roth.